Be ready for the dictation. Start. These appeals by special leave are directed against the order of the High Court of Judicature at Jabalpur in election petition number 3 of 1998 as well as against the order dated 31st January 2001 in the said election petition. The appellant is the successful candidate from Lok Sabha constituency in the state of Madhya Pradesh. The respondent filed an election petition which was registered as Election Petition 3 of 1998 impugning the election of the appellant alleging corrupt practice under Section 123 of the Representation of People's Act inasmuch as the appellant is alleged to have incurred or authorized expenditure in contravention of Section 77 of the Act. It may be stated apart from the aforesaid allegation of corrupt practice there was no other allegation in the election petition. The appellant had won the election by defeating his nearest rival by 150,000 votes. In the election petition, the appellant filed two applications seeking dismissal of the election petition on the ground that the said petition does not disclose material facts with regard to alleged corrupt practices as required under Section 83 of the Act. It was also urged that the accompanying affidavit is too vague and is not in accordance with the proviso to Section 83 of the Act. The appellant also prayed that several paragraphs of the election petition should be deleted as it has no connection with the allegation of corrupt practice within the ambit of Section 123. It was also prayed that the election petition having not disclosed any triable issue the same is liable to be dismissed. The learned judge who had been appointed as election tribunal by his order came to hold that the pleadings in paragraphs 3, 4 and 19 are wholly unnecessary and frivolous and deserve to be struck down and accordingly directed for striking out those paragraphs. But so far as the allegation of corrupt practice on the ground that the amount spent exceeded the ceiling on election expenses, the learned judge came to hold that the material facts with regard to the ingredients of the cause of action for the alleged corrupt practice has been disclosed and, therefore, the election petition cannot be dismissed in limine. The appellant thereafter filed yet another application seeking review of the aforesaid order, and that review application was rejected by order, hence the present appeal. Learned senior counsel appearing for the appellant contended that the validity of Explanation 1 of the Representation of People's Act 1951 having been upheld by this court in the case of Union of India unless an election petition contains averment to the effect that the returned candidate either has incurred or has authorized expenditure to be incurred by the election agent more than the ceiling prescribed under the Act, a mere vague allegation will not make an election petition maintainable to be tried under Section 123 of the Act, and in the case in hand after striking out of the paragraphs as per the order of the High Court on the assertions made in the residue of the paragraphs do not make out an allegation of corrupt practice within the ambit of Section 123 of the Act, and as such the election petition was liable to be rejected, and the High Court committed error in rejecting the said submission of the appellant. Mr. Venugopal further contended that the allegations of corrupt practice being quasi-criminal in nature, the pleadings require a strict examination and, therefore, there should not be any vagueness in the allegations made which a returned candidate would be required to meet. According to Mr. Venugopal, on vague and general allegation without giving any particulars, it is difficult to hold that there exists a triable issue. Therefore, the High Court committed error in not dismissing the election petition. According to Mr. Venugopal, the election petition cannot be entertained to have an inquiry and, therefore, it is obligatory on the election petitioner to give requisite facts, details, and particulars of the corrupt practice with exactitude, and in the absence of such particulars, the election petition must fail at the threshold. Mr. Venugopal further urged that on a true construction of Section 83 of the Act, more particularly proviso to Section 83, the source of information is required to be given in the affidavit, and the same not having been furnished, there has been an infraction of requirement of law. An election petition ought to have been rejected on this ground also. Learned senior counsel appearing for respondents, on the other hand, contended that the material facts and material particulars are not one and the same thing. Material facts are those primary facts which disclose the cause of action, and those primary facts have to be specifically pleaded, and failure to do so will result in rejection of the election petition. But if such material facts have been pleaded, then the rest would be a matter for trial, and, therefore, in the case in hand, since the election petition did contain the material facts alleging that the returned candidate had spent more than the ceiling provided for, the election petition could not have been rejected at the threshold, and on the other hand, there exists a triable issue which can only be adjudicated after evidence being led. In this view of the matter, the impugned order of the High Court does not suffer from illegality requiring interference by this court. After striking out of the paragraphs from the election petition in pursuance of order of the High Court, whether on the residue of the averments can it be said that material facts leading to the allegation of corrupt practice have been pleaded, or the allegations are such that it would involve a chance or conjecture for the court to draw inference by adopting an involved process of reasoning to arrive at a conclusion that the petition contains an averment of expenditure beyond the prescribed limit, and as such, a triable issue still exists. Whether non-mention of source of information in the affidavit constitutes an infraction of the provisions of Section 83 of the Act, and as such is fatal to the maintainability of an election petition. Coming to the first question, Chapter 8 of the Act deals with election expenses. Under Section 77 of the Act, every candidate at an election, either by himself or by his election agent, is required to keep a separate and correct account of all expenditure in connection with the election incurred or authorized by him or by his election agent between the date on which he has been nominated and the date of declaration of the result thereof. Subsection 3 of Section 77 provides that the total of the said expenditure shall not exceed such amount as may be prescribed. The expression prescribed has been defined in Section 2 to mean prescribed by the rules made under the Act. Under Section 123 of the Act, incurring excessive expenditure than the maximum amount prescribed would tantamount to corrupt practice. But the said expenditure has to be incurred either by the candidate or by his election agent or by a person authorized by him, and further such expenditure must be between the date of publication of the notification